Under Chapter 4, we will discuss amendments of Essential Commodity Act. There are many essential amendments. The Essential Commodities Amendment Act 1976 amended Section 3 Clause B. The Essential Commodities Special Provisions Act 1981, which came into force with effect from 1st September 1982, is effective for a period of 5 years by the Essential Commodities Special Provisions Continuance Act 1987. It is not applicable to the Union Territories of Andaman and Nicobar Island, Arunachal Pradesh, Dadar and Nagar Haveli, Lakshadweep and Mizoram. The Essential Commodities Amendment Act 1984, which came into force with effect from 1st July 1984. The Essential Commodities Special Provisions Amendment Ordinance 1992, number 12 of 1992, promulgated by the President in the 43rd year of the Republic of India, an ordinance further to amend the Essential Commodities Special Provisions Act 1981 and to make special provision by way of amendment to the Essential Commodities Act 1955. Now, therefore, in the exercise of the powers conferred by the Constitution, the President is pleased to promulgate the following ordinance. 1. This is called Ordinance of the Essential Commodities Special Provisions Amendment Ordinance 1992. 2. It shall come into force at once. After Section 9 of the Principal Act of 1955, the following section shall be inserted, namely Section 9A in the Essential Commodity Act 1955. After Section 10A, the following section shall be inserted, namely Section 10AA. Notwithstanding anything contained in the Code of Criminal Procedure 1973, no officer below the rank of an officer in charge of police station or any police officer authorized by him in this behalf in writing shall arrest any person accused of committing an offence punishable under this Act. The Essential Commodities Amendment Bill 2010 was introduced on August 9, 2010. It seeks to amend the Essential Commodities Act 1955 to clarify the price payable for levy sugar procured for public distribution system. Under this chapter, we are going to discuss seizure and confiscation of essential commodities and penalties for that. Therefore, it is essential to know in brief the distinction between seizure and confiscation. The expression seizure means to take possession contrary to the wishes of the owner of the property, and that such action is unilateral action of the persons seizing. The person from whom anything is seized loses from the moment of seizure the right of power to control or regulate the use of that thing. The dictionary meaning of the word seize means to lay hold of suddenly or forcible, to take hold of or to reach and grasp, to clutch. It also means to take possession of or operation of a warrant, order of court or other legal processes. A reference to some provision of the codes of criminal procedure shows that the term seizure had been used therein in connection with the taking of actual physical possession of movable property. Now, the confiscation means, according to Wharton's Law Dictionary, is condemnation and adjudication of property to the public treasury as of goods seized under the Custom Act. According to Trout's Judicial Dictionary, must be an act done in some way on the part of the government of the country where it takes place and in some way beneficial to that government, though the proceeds may not strictly speaking be brought into its treasury. In State of Kerala versus Mathai in 1961, it was pointed out that confiscation is not to be considered part of the sentence for an offence, but is also only a mode by which courts can dispose of property which comes before it in the criminal trials. That being the general distinction between confiscation and seizure. In the context of Essential Commodities Act, it would be seen that an essential commodity which has been seized could be confiscated. Therefore, confiscation is an action posterior to the seizure of the essential commodity. A commodity that had not been seized cannot be confiscated. Seizure itself does not imply confiscation. The Essential Commodities Act envisages two independent proceedings against a person charged with contravention of the provision of the Act. Under section 6A, the collector can confiscate the seized commodity, and under section 7, the contravention would be punishable. Confiscation of essential commodities is a sharp weapon which the Act has empowered to the central government. Under section 6A of the Act, which provides that where any essential commodity is seized in pursuance of an order made under section 3, a report of such seizure shall be made without any unreasonable delay to the collector of the district or the presidency town in which the essential commodity is seized. The collector at his discretion may direct for the production of the seized commodity before him, and if he is satisfied that there has been contravention of the order, he may pass an order for confiscation of the essential commodity so seized, or any package, covering or receptacle in which such essential commodity is found, and any animal, vehicle, vessel or other conveyance used in carrying such essential commodity, provided that without prejudice to any action which may be taken under any other provision of this Act, no food grains or edible oil seeds seized in the pursuance of an order made under section 3 in relation thereto from a producer shall, if the seized food grains or edible oil seeds have been produced by him, be confiscated under this section, provided further that in the case of any animal, vehicle, vessel or other conveyance, the owner of such animal, vehicle, etc. shall be given an opportunity to pay in lieu of its confiscation a fine not exceeding the market price at the date of seizure of the essential commodity sought to be carried by such animal, vehicle, vessel or other conveyance. The Act uses the expression confiscation and seizure in section 6A, and under this section, a commodity which has been seized in pursuance of an order under section 3 can be confiscated under the circumstances mentioned in section 6A. Now, the sale of confiscated commodity can also be done under section 6A clause 2, which provides that where the collector on receiving a report of seizure or on inspection of an essential commodity under subsection 1 above is of the opinion that the essential commodity is subject to speedy and natural decay, or it is otherwise expedient in the public interest so to do, he may sell according to procedure given by this Act. Now, the disposal of sale proceeds of confiscated goods. In terms of section 6A clause 3, the sale proceeds of the essential commodity sold after deduction of the expenses of any such sale or auction or other incidental expenses relating thereto, shall be paid to the owner or the person from whom it is seized in the following circumstances: A. Where no order of confiscation is ultimately passed by the collector. B. Where an order passed and appeal under subsection 1 of section 6C so requires. Or C. Where in a prosecution instituted for the contravention of the order in respect of which an order of the confiscation has been made under this section, the permission concerned is required. Now, the issue of show cause notice before the confiscation of essential commodity. Before passing an order for confiscation under section 6A in terms of subsection 1 of the section 6B of the Act, the owner of the essential commodity, package covering, receptacle, animal, vehicle, vessel or other convenience, or the person from whom it is seized is required to be given a notice in writing informing him of the grounds on which it is proposed to confiscate the above goods, and to provide him an opportunity of making a representation in writing within a reasonable time, and give him an opportunity of being heard in the matter. There can be appeal against the confiscation order under subsection 1 of section 6C. Any person aggrieved by an order of confiscation may appeal to the state government concerned within 1 month from the date of passing an order. The state government shall give an opportunity to the appellant to be heard and pass such order as it may think fit, which can be modified, confirmed or annulling the order appealed against. Confiscation under section 6D, which provides that the award of any confiscation under this Act by the collector shall not prevent the infliction of any punishment to which the person affected thereby is liable under this Act. The 1976 Amendment Act has inserted section 6E in the Act, which provides that no court, tribunal or authority shall have any jurisdiction to make an order with regard to the matters falling within the purview of this Act, particularly wherever an essential commodity is seized in pursuance of an order made under section 3, when the collector or the judicial authority appointed under section 6C shall have the jurisdiction. Now, we will discuss offences and penalties under the Act. Cognizance of offences under section 10A of the Act declares that notwithstanding anything contained in the Criminal Procedure Code 1973, every offence punishable under the Act shall be cognizable. A cognizable offence is one where under the Criminal Procedure Code or any other law in force, a police officer may arrest a person without a warrant. Section 11 lays down that before a court can take cognizance of any offence punishable under the Act, the following three conditions must be satisfied. Number 1, there must be a report in writing. Number 2, the report must be made by a public servant as defined in section 21 of Indian Penal Code, or any aggrieved person or any recognized consumer association. Now, under section 15A, if any public servant is accused of any offence alleged to have been committed by him while acting or purporting to act in the discharge of his duties in pursuance of any order made under section 3, no court can take cognizance of such an offence except with the previous sanction of a central government in case the person who is employed in connection with the affairs of the union, and the state government in the case of a person who is employed in connection with the affairs of the state. Under section 7 of the Act, which deals with penalties, the contravention of an order passed by the central government under section 3 with reference to clause H or I of the subsection 2 thereof is punishable with imprisonment for a term which may extend to 1 year and also with fine, and section 7 clause 1a, which provides for contravention of an order with reference to the clauses of subsection 2 of section 3, the punishment is imprisonment for a term ranging from 3 months to 7 years, and in addition fine is also leviable. Further, if any person contravenes any order made under section 3 or any property in respect of which the order has been made and contravened shall be forfeited to the government, and any package covering or receptacle in which the property is found and any animal, vehicle or vessel or other convenience is used in carrying the property could also be forfeited if the court so orders. If any person to whom a direction is given under section 3 clause 4 and clause B fails to comply with it, he shall be punishable with imprisonment for a term which shall not be less than 3 months, but which may extend to 7 years, and shall also be liable to fine. If any person convicted of an offence under section 7 1 and or section 7 clause 2 is again convicted of an offence under the same provision, he shall be punishable with imprisonment for the second and for every subsequent offence for a term which shall not be less than 6 months, but which may extend to 7 years, besides fine. For adequate and sufficient reason, the court can award imprisonment for a term less than 6 months, where an offence is committed for a second time. Besides the above punishment, the court can also order that the person shall not carry on any business of that essential commodity for such period not being less than 6 months, as may be specified the court. Now, the mens rea is very important. In Nathulal versus State of Madhya Pradesh in 1966, it was held by the Supreme Court that mens rea means a guilty mind is an ingredient of the offence punishable under section 7 of the Essential Commodities Act 1955. That is, an intentional contravention of an order made under section 3 is an essential ingredient of an offence under section 7. In other words, if the dealer did believe bona fide that he could store the food grains, for instance, without infringing any order under section 3, there could be no contravention under section 7. It was observed by the Supreme Court in the case that mens rea is an essential ingredient of any criminal offence. Mens rea by necessary implication may be excluded from a statute only where it is absolute and clear that the implementation of the object of the statute would otherwise be defeated. The nature of mens rea that would be implied in the statute creating an offence depends on the object of the act and the provisions thereof. Now, the culpable mental state, which provides under section 10C, where the presumption of culpable mental state, which includes intention, motive, knowledge of fact and the belief in a fact. It is now provided that in any prosecution for an offence under the Act which requires a culpable mental state on the part of the accused, the court shall presume the existence of mental state. Of course, it is open to the accused to prove that he had no such mental state with respect of the act committed by him. Now, under section 8, which provides attempt and abatement, that any person who attempts to contravene or abates a contravention of any order made under section 3 shall be deemed to have contravened that order. A false statement is also important under the Act. Under section 9, for false statement, imprisonment for a term which may extend to 5 years or with fine or with both for the following offences. 1. When required by any order made under section 3 to make any statement or furnish any information, makes any statement or furnishes any information which is false in any material particular which he knows or has reasonable cause to believe to be false or does not believe to be true. Or second, makes any such statement as aforesaid in any book, account, record, declaration, return or other document which he is required by any such order to maintain or furnish. Now, under section 10 clause 1, which provides offences by companies, that if the person contravening an order under section 3 is a company, every person who at the time of the contravention was in charge of and was responsible to the company for the conduct of the business of the company shall be deemed to be guilty of the contravention and shall be liable to be punished accordingly. Now, under section 10b of the Act, which provides that the court may cause to be published in newspaper or in other manner at the expenses of the company the names and place of the business and the offence contravention committed by it when a company has been convicted. Now, it may be concluded that the Essential Commodities Act 1955 was enacted for regulating, control and distribution of certain essential commodities. The central government has power to control all the activities relating to essential commodities. Moreover, it may delegate its power to state government and union territories. The central government, by amendment to this act, added onion and potatoes to control price rise in India. Though it is very good legislation, but corrupt practices are still there. Therefore, people's awareness and strict punishment is required for control and distribution of essential commodities, which can play a good role in changing Indian economy. Now, government is planning to introduce amendment bill for this act. Let us see how far this amendment bring changes in the market of essential commodities. With all this information, here we came to the end of the today's lecture. Do keep in mind what we have discussed today. It's time for you all to do some self-study. If you want to learn more and enhance your knowledge, you may log on to our website for more information, that is www.cec.nic.in. Till then, goodbye.